Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, there is a newly filed case in New Hampshire. Some people are making it out to be this huge, massive case. I don't think it's that, but it is an amazing opportunity to have a teachable moment or a learning opportunity because we get to learn about the effects that the Second Amendment may have on your Fourth Amendment right to be free from unreasonable government searches and seizures. What if I told you that being a student and a lawful and responsible gun owner actually forfeits your Fourth Amendment right to be free from unreasonable government searches and seizures? You'd say that's pretty crazy. Well, that's exactly what this lawsuit is about. So today, let's break it all down for you. Let's get you educated and let's talk about the school that forcibly searches cars because you're a gun owner. Okay, America, this story broke a couple of days ago. We had an opportunity to actually sit down with the complaint and actually go through it before we did this video because we kind of wanted to understand what truly happened here. What we're going to do today is we're going to have an opportunity to talk about the intersection of our Second Amendment rights and our Fourth Amendment rights. Okay, we all think we know the Fourth Amendment, which does prevent government from conducting unreasonable and unlawful searches and seizures. The actual text of the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Okay, is there constitutional implications here? That is there a government action? Well, we are talking about a public school district in the state of New Hampshire. So the answer to that is yes, there is governmental action here. Now, a quick lesson on how searches work legally. Okay, if we go back to our burdens of proof here, we will see that in order to stop, seize, or briefly detain a person, you only need a reasonable and articulable suspicion. To conduct an actual search or to get a search warrant, we actually need a slightly higher level of proof of probable cause. Now, there are exceptions to the warrant requirement, one of which being consent. The owner of the property could consent to that search, and there are other exceptions that we don't need to bore ourselves with today. However, when it comes to the school settings, and there is a litany of case law on that, the rule of law is that students have a lesser expectation of privacy while in the school setting than they would in their private homes. And ultimately, search and seizure laws are based on the individual's expectation of privacy. And so therefore, most searches in the school setting do not require probable cause, but rather just require a reasonable suspicion. Okay, now to get you set up on this, let's go through the players in this lawsuit. The first is 18-year-old Jack Harrington, who at the time was a high school student at a public high school in New Hampshire. In the state of New Hampshire, an 18-year-old can lawfully own a handgun, which he did. And since it is a constitutional carry state, even the 18-year-old could lawfully carry the firearm in their car. So I want you to know, by all accounts, Mr. Harrington is absolutely a lawful, responsible, gun-owning New Hampshire resident. There are also 3 school district employees that we're just going to collectively refer to as the school district. We will, again, link up the complaint down below so you can see their specific names, but that does include the principal, the vice principal, and the school resource officer. Okay, this story begins in April of this year where Mr. Harrington was on a bus going to a varsity basketball game and had a conversation with another student about getting pulled over a few weeks earlier while he had the firearm in his car in the glove box. He merely told the story about how nervous he was. He didn't know how to properly handle that situation with the officer, and also complimented the officer about how cool he'd been about the whole deal. Now, apparently some other students on the bus heard that conversation and then reported at least parts of it to the school district officials. But interesting to note about this conversation, as articulated in the complaint, notably, at no time did Jack tell anyone, including teammates or coaches, that A, he intended to bring his handgun to the HDHS campus, B, that he had ever brought his handgun to the HDHS campus, C, that he intended to use the handgun in an unlawful manner, or D, that the interaction with the police officer occurred on the school campus or anywhere near the campus. It did not. Jack merely told his teammates that his handgun had been in the glove box of the subject vehicle when he was driving on the single occasion in question, which again took place off campus and outside of school hours. So all the school district is aware of at this point is that Jack is a gun owner. Jack at one point did have his firearm in his car, and a traffic stop occurred, which turned out to be rather uneventful. That's the only data, the only information that the school district has. Yet, according to the complaint, as described in more detail below, defendants took 2 data points delivered to them through a high school rumor mill to support their conclusion that Jack was in possession of a firearm on school property on April 24, 2025. Jack would confirm that A, he was a lawful firearms owner, and B, at some point he had lawfully stored the firearm in the glove compartment of a vehicle. These 2 data points hardly gave rise to the bare minimum of reasonable suspicion necessary to justify a search. But you see, then on the morning of April 24th, Mr. Harrington is yanked out of class and taken down to the principal's office, and then he is interrogated by the principal and the vice principal and the school resource officer, and he admits that yes, he is a lawful and responsible gun owner. Yes, he admits that he has carried the firearm at least on 1 occasion in the glove box. He is adamant that the firearm is not on school property, that the firearm has never come to the school property, and that he has no intention of bringing the firearm to the school property. But that's not good enough for the school officials, because they start telling him that we need to search your car. Mr. Harrington, knowing he hasn't done anything wrong, is not willing to acquiesce or consent to that search and basically tells them no on multiple occasions. But the school district officers can repeatedly tell him that you have no choice in this matter, that one way or the other, we are in fact going to search this car. Mr. Harrington, in such a distressed point, actually at one point calls his parents, who communicate with Mr. Harrington and the school district officials on a speakerphone, and both mom and dad also declare to the school district that they are not going to consent to the search of the vehicle. At one point, one of the school officials was quoted as saying, "This is a school issue, not a police issue." Which means at that point, the school district officials themselves are saying, we don't have any reasonable suspicion of criminal activity. Because if a student, or anyone for that matter, brought the firearm to school property, that is a crime under New Hampshire state law. But the school officials at no point even considered getting law enforcement involved. So where we are at this point is the school district is operating on 2 data points that has no connection whatsoever to any type of alleged criminal activity. They have now confronted the individual, they have interrogated the individual, and the individual has given them no other information that would expand upon any suspicion that they may have had. They have then asked for a consent to search the vehicle, which has been denied on multiple occasions, not only by the student, but by the student's parents anyways. So what does the school district do? Well, they search the car anyways. And because Mr. Harrington was not willing to unlock his vehicle and thus acquiesce to that search, they forced open the locked door of the car, rummaged through the entire vehicle, and what did they find? Absolutely nothing. Why? Because Mr. Harrington had told school officials that the firearm was being stored properly at home, and at the time of the search of the car, the firearm was exactly where Mr. Harrington had said it was. The complaint, as it relates to this search, specifically states, while in the parking lot, still surrounded by the interrogators, Jack, with the keys in his pocket, silently watched as school officials forced the subject vehicle's locked doors open and searched through his belongings, finding no firearm. Now, the school district has done 2 things, and they kind of know that they probably stepped in it a little bit. Number one, they have tried to label this not as a search, but a view. We could get into the difference between plain view and searches. We don't need to geek out on that today. The second thing they're claiming is that Mr. Harrington actually and ultimately consented to the search, which is the furthest thing from the truth. And even if he had had consensual words come out of his mouth, there is a very plausible argument that that consent was coerced through the interrogation. So what do we have here? We have a violation of the student's Fourth Amendment rights by school district officials who are what? That's right, acting under the color of state law. That leads count 1 of the complaint to allege, count 1, violation of the United States Constitution, 4th and 14th Amendments, under 42 United States Code Section 1983, illegal and unreasonable search. And again, going back to our levels of proof right here, the plaintiffs in the complaint allege, ordinarily a search, even one that may be permissibly carried out without a warrant, must be based on probable cause to believe that a violation of the law has occurred. The lower reasonable suspicion or reasonableness under all circumstances standard is generally applicable to school searches. Either way, the fundamental command of the Fourth Amendment is that searches and seizures be reasonable. But you see, when you are conducting a search under no articulable facts of criminal activity whatsoever, there is nothing reasonable about that search. So, what exactly is the plaintiff asking for? Is he asking for multi-millions of dollars in a settlement or anything like that? No, he's not. And this is why some of the people out there who are making this out to be a really, really big deal probably should have read the complaint a little more carefully, because this isn't about money. This isn't about recovering damages. This is about getting a moral victory. This is about getting a declaration from the court that he was wronged. And it's not about anything beyond that, okay? Because the remedies, because remember, we got to have remedies, right? If we don't have remedies, we don't have a lawsuit. What exactly is the plaintiff asking for here? It's this. A, count 1, declaratory judgment that the interrogation and the illegal search were unconstitutional. B, on count 1, at minimum, nominal damages. Nominal damages is usually $1, okay? So he's not asking for monetary damages. Finally, they're asking for, on count 1, plaintiff's attorney's fees and the costs associated with this action pursuant to 42 United States Code Section 1983, together with an award of prejudgment and post-judgment interest at the highest lawful rates. So, in a nutshell, he's asking the court to declare, yes, this was unconstitutional activity. Here's your $1 in monetary damages. And yes, the school district will have to pay for all of your attorney's fees. But America, what I want you to understand is this, is that there is an outright war going on our inalienable Second Amendment rights, and it's coming from all fronts. It will come from school districts, it will come from banks, it will come from credit card processing, it will come from insurance companies. They will try every possible way to disarm all of you. And this is a classic example here, where just the mere mention of the word gun puts people in a position where they will act so erratic, so irrational, that they are actually willing to intentionally and obviously violate the constitutional rights of one of their own students. Okay, the case once again is Harrington v. Crawford, filed in the United States District Court for the District of New Hampshire. We're going to link up the complaint down below so that you can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.